know. I know. Now I've dealt with bed bugs here. I've dealt with a lot of stuff
All right,
in
sir.
my
Are
life
you
right
gonna,
now.
sir? Are you gonna have an attorney represent you in this matter?
No, no, I want to pay it all. No, 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 no. I want. I have a week to pay this.
Sir, you have a week to show up for another hearing.
I just, I just, I paid my bills. I let this woman borrow money from me, and I need a little more time. I
Sir,
need a little more time, sir.
Yeah, I
pardon?
thought you said you remember me.
I,
I'm hearing things.
I know who you are. Okay, Mr. Gann, how much is owing?
Currently, the rent is $3,728.04. Court fees of $252.80 for a total of $3980.84. 3980.84.
All right. Ms. Munson, how are you intending on getting?
I've been working with the Housing Resource for Seniors.
Housing Bureau for Seniors?
Yes.
Okay.
Yeah. And I thought she called. She said she was gonna call and
Do you know who she was supposed to call?
the the court
And what did you think she'd tell us then?
that I'm working with.
Working with them?
Uh-huh.
Okay, let's do it this way. I'm not sure in the skip funds how much is still there, but there certainly are resources that would be available for seniors. So what I'm going to do, ma'am, is I'm going to put your case over to the 24th, next Friday, 2026 at 12 noon. At 12 noon.
Okay.
Okay. Whoever it is that said they were going to contact somebody, get on them and make sure they get the information either to myself or to your landlord.
All right.
Okay.
Okay.
And let's see if we can resolve it somehow or another. Okay.
Okay. Thank you.
You're so welcome. Have a good day.
Oh.
Razat Huron versus Dennis Wilson.
Hey, please, Your Honor, of court, Steve Gann for the plaintiff.
Hi, I also just want to let you know, Your Honor, that my name is Caitlin McGill and I'm from Adult Protective Services. For the
Oh, okay.
client.
Very good. Thank you.
Hello?
Yep. Hello.
Okay.
We got you, man. I'm just
Okay.
waiting. He's coming up to see me.
Thank you.
All right. Okay, sir, what's your name?
Dennis Wilson.
All right. And Mr. Gann, how much is owing?
Currently, Your Honor, the balance is $2,594.02 plus $219.72 in court fees for a total amount of $2,813.74. 2813.74.
All right. And sir, you got folks with you, but how do you think you're gonna get this paid?
Well, I'm working with, is she here?
Yeah. You're
Oh.
looking for
Working with her.
Bill? All right. Ma'am, can you apprise me like where
Yes.
he is
Yes.
and everything? Just hold on a second. Sir, if you want to sit, you can sit. You don't have to stand. Whatever, however you're going to be comfortable.
I can use this one easier for me to get out.
Okay. Got it? Okay. All right. I'm sorry. Go ahead, ma'am.
Hi, so my name is Caitlin McGill. I work for Adult Protective Services and I've been involved with the client since May 29th of 2026. At that time, I had concerns about his mental capacity. ability to pay his rent, as he has a long history of these kind of issues. So I've been working with Michigan Ability Partners as well as Huron Valley PACE, who they had made an agreement back in May of 2025 that the client's brother would become his payee. The issue that happened with that is that there was not follow through on that, and the client either got confused or did not approve that with Social Security. So that never came to fruition. So basically, from my investigation, these different agencies like Michigan Ability Partners and PACE were supposed to follow through and kind of help the client make sure these things were taken care of. And that unfortunately did not happen. So now I am working with my management as we have APS funds that could pay at least $2,000 of the balance. And also we are trying to secure the client to get his voucher back through the CHIP committee, which is through Michigan Ability Partners. Because in order for DHS and APS to pay the balance, we need to make sure that moving forward, he still has his voucher so he can afford the rent, right? But to be honest, this is a situation where I felt from the beginning of meeting him that he did not have capacity, and that things have fallen through the cracks, not because of his own fault, but because different agencies have not followed through on what they need to do. So I am just respectfully asking that we be given some more time, as I am trying to get this all taken care of so that he is not evicted.
Okay. So how soon could the 2,000 be paid? Do you know?
So, I mean, at this time, I'm just trying to work with, because a psychiatrist on 7/1 activated the client's financial power of attorney, which is his brother.
Got it.
So now we have to go through the process of getting that taken care of. But in regards to 2,000, I mean, I could probably get a letter saying that we are going to pay it. I'm hoping early next week. I'd have to get them into our system to have them paid. I'm also going to ask that the client's brother and son ensure that when he gets his Social Security on the beginning of August, that he make a substantial payment towards the balance.
Got it. Okay. All right.
If I can
Mr.
clarify, Your Honor,
Yes, sir.
when she spoke earlier, I just want to make sure I understand. She indicated that they could pay 2,000, but only if he's able to get a voucher reactivated. So if the voucher is not reactivated, does that mean the 2,000 doesn't come in? And how long will that voucher take to be reactivated? Approximately.
So, I mean, it's very hard to say. I have to work with these other agencies, right? They have a committee that meets next week sometime. So they're gonna vote on it at that time. And I've gathered different information from doctors, right, that have shown he does not have capacity. And all I can say is that I will do my best to have it as quickly as possible. And I just ask that the court and the attorneys give us a little bit more time.
Okay. And I think that the issue, Mr. Gannon, at least I understand it, is it's going to be an issue of sustainability as to whether or not that voucher's reactivated. But I think if she can get the letter, then we're going to try to work and get as much breadth to it so that we can try to get the rest paid. And then once the Social Security comes in, and if somebody's there to do that, they can make a substantial payment at the beginning of the month. What's his monthly rent, Mr. Gann?
Currently, Your Honor, it is $1,274, and he has a washer and dryer fee of $35. So we're talking, what's that?
In the $1,300.
$1,319.
Got it. Okay. So,
And
all right.
Your Honor, I am going to speak with his son as well as his brother and ask that they make a payment if they are able to. His son has already made a $500 payment at least, but I'm going to see if he can make another one as soon as possible to try to get this balance as low as possible. I will say that I think that I have a very good chance of getting the CHIP committee to give the voucher back based on all the evidence that I have that the client was exited from the program when he did not have capacity to like follow through on the things he needed to when he was exited.
Okay. I'm going to take it. I'm going to push this out. So the first thing we'll do, ma'am, is I'm going to adjourn it to next week,
Yes.
the 24th, 2026 at 12 noon.
Okay.
That way we can check on whether or not
Yes.
the letter.
Yeah.
And other information that you have, because, we can check on that, whether or not then there are other payments by family members and how things are looking, and then see where we proceed from there. Okay?
Yeah.
Thank
I
you.
am
That's
hoping, to my understanding, Chip,
Pardon?
I'm sorry. Thank you. That's exactly what I was
I was just going to say, to my knowledge,
Okay.
Go ahead,
all
Ms.
right.
McGill.
sorry.
Go ahead, Ms. McGill.
I was just saying, to my understanding, Michigan Ability Partners is meeting with the CHIP committee next week sometime. I'm hoping around Wednesday, and I will be presenting them the information that I've been able to get together, and then they're going to vote. And so I'm hoping by 12 p.m. on this next hearing date, which I will be there for, I will be able to say that my supervisors have approved the payment
Okay.
and that we can move forward that way.
All right. Very good.
And
Okay.
Ms. McGill, if there's anything you need from my client, feel free to reach out to me if you need anything from my client to help with your documentation.
All right.
Yes, thank you so much.
All right. Thank you, sir. You have a good weekend, okay?
Thank you, Your Honor. Thank you.
Thank you.
Thank you. Bye-bye.
Thank you, Aaron. I believe that's my last case for today. I hope you have a great
Yes, sir.
weekend and try and avoid the smoke.
Yes, exactly. You too, sir. Harbor Meadows versus Terry Joe Duell. Good afternoon. Your name?
Terry Duell. I'm sorry.
Go ahead.
Good afternoon, Your Honor. Michael Burns, P 87855 on behalf of plaintiff.
All right. And what is the claim now?
Thank you, Your Honor. This is a non-payment possession only case, and parties have been able to resolve it through a consent judgment. I can place the terms on the record.
Yes, go ahead.
Thank you, Your Honor. Rent to retain is $3,207.46. We have cost the amount of $178 for a total of $3,385.46. Parties agree that defendant shall pay $500 on or before 7/17/2026, $400 on or before 7/31/2026, and 8/14/2026, and the remainder on or before 8/31/2026. I explained MCR 4.201J to Ms. Duell, and she executed the consent judgment with those terms.
All right. And counsel, at the last hearing, we were given that her balance was 2,000, including cost, 2,361.75. So I'm trying to figure out how it climbed.
Don't see it past due in the last one. I'm looking at the ledger right now, Your Honor. There was,
I believe it's July's rent.
yeah, that would be my understanding. I'm just confirming what the last date was, but
July 10.
yeah, I know that's why I would be confused as to why the increase. I'm looking at my ledger, Your Honor, and everything looks to be in order. I can provide the court a copy of the ledger. What was the number the court had at the last hearing?
2,361.75.
That may be without July's rent included, but I'm looking at my ledger and that would be the only thing that would have changed. Parties have gone over things. The manager was here. Everybody's in agreement as to the numbers. So I don't, yeah, it could have been a misstatement on my part to the court then again, Your Honor. So I apologize if that may be the case, but nobody's disputing the amount and everybody's in agreement.
Is that correct,
Yes,
ma'am?
sir.
You're not disputing?
I am not. No, it's
Okay.
for July's rent.
All right. Very good. Do you have any questions whatsoever on this?
No, sir.
No? All right. And you think you'll be able to get it done? All right. Very good. I'll enter that judgment.
Thank you.
Thank you, Your Honor. That's the only one for me.
You guys have a great one. Then I have Westridge Mobile Home Park versus Michelle Cates.
That one should be dismissed, Your Honor.
Okay, yeah.
Okay.
That case is dismissed on plaintiff's motion. What is, ma'am? Okay. Yeah, you were set earlier in the day.
Set at noon today.
Yeah, you were set at noon. What are we? Okay, we're trying to figure out what happened. Hold on.
You
It would be default.
Okay, default judgment. Okay, ma'am, we issued a default judgment. You'll have to come back to the court on Monday and fill out paperwork to set aside the judgment. Do we have an amount on there or no?
I'm sorry, it did not get caught.
Okay. That means we entered a judgment because you weren't here. Okay. And so you'll have to come in and pick up a form to try to set that judgment aside. Okay. And our clerk's office is about to close or did close. So you have to do that on Monday. All right. Thank you. I think that's it for us. Thank you, Alan. Thank you, Ann.
The Honorable Judge JudgeSimpson presiding.
And good morning. Court calls the case Danny Noonan LLC versus Nicholas Jarvella.
Good morning, Your Honor. David Fantier on behalf of the plaintiff.
Not checked.
Jarvella? No response. If you'd like to take a default, please raise your right hand.
I no response. I want to respond.
Hold on a second, sir. Sir, hold on. You didn't put your name in. What's your name?
Nicholas Jarvella.
Okay, very good. All right. Then, Mr. Fantera, what is plaintiff's claim in this case, including court costs?
He has a balance, including court costs and July's rent, of $1,105.
All right. Mr. Jarvella, how are you intending on getting that paid, sir?
No, I have my buddies. I'm at 9:15. I'm under $1,000 and I'm going to pay this by September.
Well, I don't.
Dude, my man, I had problems with owing people money, and I don't want to be evicted, but I know that I can pay this by September.
Okay, you're gonna have to try to work that out with the landlord because I can't get you through to September.
I know. Now I've dealt with bed bugs here. I've dealt with a lot of stuff.
All right, sir.
In my life now.
Sir, are you gonna have an attorney represent you in this matter?
No, I want to pay it all.
Okay. Then what I'm gonna suggest you do is you either contact your landlord directly or contact Mr. Fantera's office. I'm gonna adjourn this out. I have the 24th, correct?
Yes.
I'm gonna adjourn it out 1 week to July 24th, 2026 at 12 noon. That is an in-person hearing, sir. So you'll have to show up at the courthouse and then we can figure out what we're going to do. All right?
No. I have a week to pay this.
Sir, you have a week to show up for another hearing.
I paid my bills. I let this woman borrow money from me, and I need a little more time.
Sir.
I need a little more time, sir.
Then what you're going to need to do if you're gonna work out a payment plan with the landlord, you're gonna either need to contact your landlord or contact Mr. Fantera's office. As far as the court proceeding, I've set it for another hearing, and that hearing is next week at noon in person. All right. Thank you.
All right, thank you.
Thank you, Your Honor.
Ian Greenlee versus Ches Williams.
Good morning again, Your Honor. David Fantair on behalf of the plaintiff.
Not checked.
Ches Williams. They are not checked in. I'm almost afraid to ask you to raise your hand. Raise your hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Yeah, I wasn't quite sure how far we got that first time.
Yeah. Go ahead.
I'm David Fantair. I'm the attorney for Ian Greenlee, and such I'm familiar with the books and records they relate to this tenancy. In this case, there's rent owing in the amount of $2,310, court costs of $175 for a total of $2,485. We'd ask for a judgment for possession with a writ after 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. Mrs. Haverkamp versus Jada Wimberly. That matter is dismissed on plaintiff's motion without prejudice.
Thank you very much, Your Honor.
Thank you, sir. Augusta Woods versus Papagaye.
Good morning, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
All right.
There's a Alessandro guy.
Yes.
Yeah, I'm right here.
Okay. Who are you?
Papa Alessandro. Yeah.
Got it. All right. What is plaintiff's claim, including court cost?
Thank you, Your Honor. This is a non-payment of rent case. We're showing rent due in the amount of $1,656.21. Cost in the amount of $195 for a total due and owing of $1,851.21.
All right. Sir, how are you intending on getting that paid?
Yeah, I'm gonna try to pay for it before the end of this month.
Okay.
Yeah.
So you're gonna try to get it all paid before the end of the month?
Right.
Okay. Do you have anything you can pay before next week?
Not yet, because I was waiting for my payment. I just got this job.
Okay. So here's what I'm gonna do. I'm going to adjourn this out 1 week, July 24th, 2026 at 12 noon. That's an in-person hearing. What I suggest you do is contact your landlord or their attorney's office to see if you can arrange some type of payment agreement, okay?
All right.
Thank you.
All right, thank you.
Augusta Woods versus Anthony Wilson.
Good morning again, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Hello, Your Honor. Anthony Wilson.
All right. He's got his camera turned on, but something's wrong. Okay. All right. What is plaintiff's claim?
Thank you, Your Honor. We are seeking a non-payment possession judgment. Rent to retain is $1,671.46. We have cost in the amount of $195 for a total due and owing of $1,866.46.
All right. And Mr. Wilson,
Yes, Your Honor.
how are you intending on getting that paid?
Well, next week I'll be able to before court to get in $800 to $1,000, and we can go from there.
All right. You're going to get $800 to $1,000 before next Friday?
Yes, sir.
All right. So what I'm going to do is you get that paid to the landlord, then we can figure out where we're going to go. I will adjourn this out 1 week to July 24th, 2026 at 12 noon. That's an in-person hearing, so you'll have to come down to the courthouse unless everything's paid.
Okay. Thank you, Your Honor. Have a good day.
You do the same, sir.
Thank you.
And that's the last one for me, Your Honor. I appreciate your time.
Yes, sir. Take care. Arbor Woods versus Kymarie Smith.
Good morning, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff. And Your Honor, I think the second defendant, Terrence Smith,
Yes.
is present.
And Terrence Smith. He's here.
Good morning, Your Honor. Terrence Smith.
Good morning. All right. What is plaintiff's claim?
With costs, Your Honor, $1,910.72.
All right. Hey, Mr. Smith, how are you guys intending on getting that paid?
Oh, it was paid yesterday.
Oh, you paid it yesterday?
Oh, yes.
The full
Oh.
1910.72, Mr. Smith?
You actually paid 1916.72 because they said it was a little more due to paying by money order.
Got it. All right. Your Honor, if we could adjourn this one for 1 week, I'll verify, and
Yep.
I'm sure we'll have the dismissal submitted. Mr. Smith, was that paid via, you said via money order?
Oh, yeah.
Okay.
All right, Mr. Smith, I'm going to adjourn this out to July 24th, 2026 at 12 noon. I'm sorry, at what time? 2 p.m. If
Okay.
everything is paid, you don't need to come down to the courthouse. It'll be dismissed out. Okay, sir?
Okay. Will I receive something saying dismiss out just so I'm covered? I don't want to.
Your Honor, if Mr. Smith wants to give my office a call next week, I mean, I would say maybe wait till like Wednesday just to be safe. It gives us just more time to verify it, but I'm sure I'll have an answer today. So, Mr. Smith, the paperwork that told you to appear today lists a Matthew Pallets out of Troy. It's a 248 number. If you
Okay.
call that number next week, I can verify whether we've gotten that confirmation from Arbor Woods.
I'm good.
Thank you.
All right. Thank you, sir. Have a great weekend.
You as well.
Coachville versus Eden Vasquez. Eden Vasquez, they are not here. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Pallets Law, on behalf of the plaintiff. There's rent to retain of $1,499.44. Costs are $175 for a total due of $1,674.44. And we'd ask for a default possession only judgment with right to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Northville Crossing versus Ashley Kuzma and Brendan Kuzma. Not checked in. Kuzma, not here. You may proceed.
Thank you, Your Honor. There is rent to retain of $7,369.47. Costs are $250 for a total due of $7,619.47. And we'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested with the writ to issue in 10 days. Scio Farms versus Bridget Long. And I think she's here. Hello, Ms. Long.
Good morning, sir.
All right. What is plaintiff's claim?
With costs, Your Honor, $2,452.55.
All right. Ms. Long, how are you intending on getting that paid?
Well, I was not aware until the 14th that it had not been paid. My adult children are supposed to be paying it. I took back over the account. I'll have it paid in full by next Friday. Not next Friday, the Friday after.
Okay, so you think you need the Friday after that?
Yes. I can
The
have half of
31st.
it paid by next Friday.
Okay, so you can have about 1,300 in by next Friday.
Yeah, I'll have like 1,300 in by like next Wednesday.
Okay, so here's what I'll do. I'll indicate that you're gonna pay that amount, the 13 by, I'll just say the 16th, or I'm sorry, the 23rd. Okay, I'll adjourn this out to July 24th, 2026 at 2 p.m. That's an in-person hearing. All right, and then we can get the matter resolved.
Okay,
Feel
hopefully
free
I'll have it all in. I just did not know until the 14th when my younger daughter was like, hey, Mom, you should look at this. So thank you very much.
Okay, all right. So get that paid, and you can always feel free to call plaintiff's office, see if you can arrange.
No, they're
It sounds
fabulous.
gonna get it paid by the end
They're
of the month.
fantastic. Thank you very much.
All right, you take care.
You too.
Sile Farms versus Amanda Ridley. Amanda Ridley, not checked in, you may proceed.
Thank you, Your Honor. There is rent to retain of $901.69, cost of $192, for a total due of $1,093.69. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Fantastic. That's that block.
For me, I'll see you at, I think, 1 o'clock. I think, yeah, 1 o'clock. Thank you.
All right, take care. Court stands in recess.
To pay any bonds that the court may try, if the court chooses to put bond on him. But he is, if I remember correctly, no communication was actually ever had with the complaining witness. It was just in the family member I spoke to.
Through third parties, as I recall.
I spoke to the father. The father was very clear that he never even told the young lady that he said he loves her. He didn't do that. He would not do that. And my client since then has had no communication with her. He was released for like 4 days.
2 days.
2 days.
I got in despair.
And he had no communication with her, so much so that he asked me if he could have somebody do a welfare check because nobody had communication with her. Your Honor, my client understands he cannot speak with her. He is not going to speak with her. He's asking to be released back on tether at this time. In the alternative, and I did send somebody to talk to my client about this, understanding that at the time, both he and the complaining witness were intoxicated in their own home. If the court is not inclined to just let him out on PR bond, could we do bond or PR2 treatment if the court does not want him just released?
Discovery is complete.
Yes, Your Honor.
We'll have their witnesses available the 28th.
Sure.
Preliminary examination will be set for July 28th, 2026 at
12 noon, what do you mean?
12 noon before me. Is there a response as to the bond argument?
Your Honor, I'll leave it in the court's discretion. I will note for the court that in some of the calls he makes to both his father and his mother, there is talk of, did you speak with the victim? And they say, yes, I believe that's the mother that he was contacting. So I do have concerns about that. I do think treatment would be a good idea. There is talk about sobriety within those calls for both the victim and defendant. So I feel that treatment would be a good option for him, given the allegations in this case, and what was discussed on these calls.
And he is in the SPARE program,
Waiting for a bed.
Yes, he was waiting for a bed, so he's not objecting to going to treatment.
I'll release him. Bond will continue as is. I will release him on a PR with other 2 inpatient treatment.
Thank you, Your Honor.
All right, thanks.
I just texted your dad.
Court calls case People versus Riley Everett.
Assistant Public Defender Daphne Leva on behalf of Mr. Everett, who appears via Zoom.
Morning, Your Honor.
Good morning, sir. State your name, please.
Riley Everett.
Thank you.
And Your Honor, we would like to set this matter for preliminary examination. Please, discovery is complete.
People have their witnesses available the 28th. All right, preliminary examination will be set for July 28th, 2026 at
9 a.m. Judge Fresh Hour.
9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you.
Thank you, sir. Court calls case People versus David Fallon.
The people, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Palin, who approaches. This is for you, okay? And can you please state your name for the record?
Requesting an adjournment.
PR, Your Honor, at this time.
I'll adjourn the matter to August. I can give you the 28th. I can do the 28th or the 6th.
There are some meetings that council has requested that I have, so I would ask.
The later date. All right. I'll adjourn it then to August 6th, 2026, 9 a.m.
All right, thank you.
Thank you.
All right, we'll be in touch, okay?
Bond continues. Court calls case versus Dallas Fritz.
Yes, and Your Honor.
Assistant Public Defender Enzo Heck. I'm gonna step out in the hall. He was here. Gallisper.
That helps you up my brains in court. I like that be from the gateway. Seriously. I think Iowa would do better than that.
Counties. Please state your name for the record.
Dallas first, Your Honor.
All right, what are we doing?
Your Honor, he's going to be waiving his preliminary exam.
Is that correct, sir?
Yes, Your Honor.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court
Yes, Your Honor.
for further proceedings. We'll also waive the right. Preliminary examination having been waived, defendants brought over to circuit court on count 1 with 2 following.
I'm sorry. Thank you.
Your turn. You acknowledge receipt of the information.
Yes, Your Honor.
You waive its reading.
I do. We waive formal.
Client stand mute at this time.
Does.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set
September 8th at 1:30 with Judge Cumke.
September 8th, 2026, 1:30. On continue.
Thank you, Your Honor. Have a good day.
Yes, Mr. Allen. Court does call the case People versus James Pittman.
Stephanie Tan on behalf of the. Say your name.
James Army Pittman.
And Your Honor, we are asking that these matters be set for exam.
Discovery is complete.
To my knowledge, yes.
All right, people have their witnesses available the 28th. Preliminary examination in both matters will be set for July 28, 2026 at 12 noon before me.
Thank you so much, Your Honor.
Thank you, Bond Wilkins. Court calls the case People versus Kendall Green Austin.
This is Public Defender Jay Bellinger on behalf of Mr. Green Austin, who appears via Zoom, Your Honor. Mr. Green Austin, can you please state your name for the record?
Kendall Green Austin.
Your Honor, we're just asking for a brief adjournment to continue negotiations.
Turn the matter to August 6, 2026, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls case of the People versus Durande Anderson.
And Assistant Public Defender Chinazi Kiriak. On behalf of Mr. Arande Anderson. Arande, state your name for the record when you get to the court.
Randy Anderson.
Thank you.
Judge asked that this matter be set for preliminary examination.
All right. Discovery is complete.
For knowledge, Judge.
We'll have their witnesses available the 28th. Preliminary examination will be set for July 28, 2026, 9 a.m. before Judge Freshow. Bond will continue. Thank you. Court calls case People versus Jermaine Hampton.
Assistant Public Defender Duffy, Leba on behalf of Mr. Hampton.
Your name, sir?
Hampton.
Thank you.
Thank you. We'll be requesting an adjournment to continue negotiation.
Preliminary exam or probable cause conference will be adjourned August th 2026, 9 a.m.
Thank you, Your Honor.
For cause case, People versus Francisco Quezada Loretta.
Joseph Barbara for the people, Your Honor.
Assistant Public Defender, Tanaza Kara Kennedy, Your Honor. On behalf of Mr.
It's like so formal when he stands up. It's like a little soldier. Go ahead. Nothing, not you. Your name, sir?
Francisco Quesada Loretta.
What are you?
Just we're asking for an adjournment in this matter. We're in negotiations with the people. I'd like to address my disclosure.
The only thing holding him?
Yes.
Probable cause conference will be adjourned to August 6, 2026, 9 a.m.
No, I let them know I was here, but she still put.
As to bond.
I just want to do my time there instead of being here.
As to bond, Your Honor, my client indicates to me that he had a status conference out in Kent County yesterday. Although they are aware that he is here, he states that they did place a hold on him. So I was wrong about that answer. This is the only thing holding.
Got a hold.
He's got a hold in Kent County. He is under sentence, or he will be under sentence there. I do not know if while he's here, they're going to allow him to get credit on the sentence that he's going to be serving out there. He is.
What's the charge out there?
What was
What's the charge?
that? Aggravated assault with a deadly weapon and CCW. I sent it to prison the other time about that 4 years. That's fine. I just want to do my time over there instead of being here.
So, Your Honor, I'll withdraw my motion now. I'll talk with them and see exactly how we can, what needs to be done to ensure that he's able to get his time done there.
All right. Bond will get.
Okay, thank you, Judge.
Thank you.
Thank you, Your Honor.
You. For cause case, People versus Robin Hardy.
Your Honor.
Where do you go to undergrad?
Loyola, Chicago, Your Honor.
Oh, that's right. I do know who you are. I didn't know you were in Iowa, though.
Yeah.
I'm still devastated.
Yeah. Well.
It's gonna take me a while to get over it.
Good morning, Your Honor. Ashley Hannibal from Ms. Hardy.
Your name?
Robin Hardy.
Gotcha. I got it. Okay. What are we doing?
Your Honor, we'd like to set this for preliminary exam.
Discovery is complete.
The best of our knowledge, yes.
All right. People have their witnesses available the 28th.
You are right, Your Honor.
Preliminary examination will be set July 28th, 2026 at
12 noon.
12 noon before me.
She's requesting that it not be the 28th if possible.
I just started a new job and I'm in my.
I'm sorry?
I just started a new job and I'm in my 90 days.
People gonna have any objection to another date?
Oh, Your Honor.
Okay.
Had to look.
That would work better for you.
Like a little parrot. All right. I'll set preliminary examination then for August 4th. Are you gonna be able to?
Can I look at my phone?
Job.
Can I look at my phone for that date?
Yeah, go ahead. Because this is taking a while. See, I don't think we.
August 4th.
All right, August 4th is good for us, Your Honor.
You keep thinking, what?
August 4th is good for us.
Good work. Thanks. I'm glad I could fit your schedule. August 4th, 2026, 9 a.m. That's before Judge Washington.
Thank you.
All right,
Thank
thank you, Your Honor.
Court calls the case, People versus Orby Huffman. Yeah. Is this it for them?
Names are not for the people, Your Honor.
Michael Gaddy, Assistant Public Defender on for Mr. Huffman.
All right, what are we doing?
Your Honor, I did have a chance to, this is a competency hearing.
Yes.
I did have a chance to review the competency report thing. Thank you for Ms. Lundy for Feltus for forwarding it to me. And I've gone over that with Mr. Huffman as well. State your name, Mr. Huffman.
Orby Huffman.
Your Honor, we don't have any additions to that report. One correction, Mr. Huffman states he was born in Ohio, not Ypsi, but raised there. Other than that, we don't have any additions or corrections, and we don't object. We don't object to the report or stipulate to the report. Yes, Judge.
Anything from the people? Looks panicked.
No, Your Honor, we also stipulate.
Based upon a review of that report, the court does find that there would indicate that the defendant is competent to stand trial, would specifically find that the defendant can understand the nature and objects of the proceedings and against him and can rationally assist in his defense. Therefore, the defendant is deemed competent.
Thank you, Your Honor.
And I'll need an order.
Yes, I'm preparing one now.
And what would you like me to set this for then?
Your Honor, I'd ask for a probable cause conference. We have a stalking matter listed as well. I don't know if that's open or closed.
He has another case.
On our files, we have a stalking matter that's just I can't tell whether that's open or closed with the court. So I didn't want them to be staggered.
A felony stalking or a misdemeanor stalking?
Looks like an ag stalk. I can pull up.
An ag, so is it up in circuit court currently?
It's yes, Your Honor, it is.
It is.
Oh, it's in circuit court now.
Yeah, that's
My,
what he said.
all right, thank you, Judge. My fault.
Okay. So is that holding him? Is that holding him? Why is everything so hard?
Your Honor, it looks like his bond was denied in that case.
Yeah, he remanded in that.
Oh, okay. So yes, answer. All right. I'll set his probable cause Vic to August 6th, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Court calls case of the People versus Tony Heskell.
The people.
Good morning, Your Honor. Ashley Hannibal for Mr. Haskell.
Your name, sir?
Tony Haskell.
Are requesting a 2-week adjournment to review discovery.
I'll adjourn it to August 6th, 2026, 9 a.m.
You advised me that he has another court date on the 6th as well.
Where?
Ann Arbor, it's a circuit court 22nd.
August 13th, 2026, 9 a.m.
All right, thank you, Your Honor.
Court calls the case People versus Ira Hill.
People.
Yeah, the Assistant Public Defender for Mr. Hill, Your Honor. He should be on Zoom.
Sir, can you unmute and state your name?
Ira Hill.
Thank you. Going.
Your Honor, I'm asking for a brief adjournment. I have had a chance to speak with Mr. Hill and Ms. Feltus. I'd ask the board to adjourn this so we can continue discussions and plan our next steps.
I'll adjourn it to August 13th, 2026, 9 a.m.
I'll be in touch, Mr. Hill.
Okay,
Court
thank you.
case versus Jacob Hodge.
Assistant Public Defender Zach Vinny with and on behalf of Mr. Hodge, who's present via Zoom. Sir, can you please state your name?
Jacob Hodge. All right, I have a plea form in front of me that indicates that the defendant will be pleading to an added count to a retail fraud second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
Is that a correct statement? Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for me.
Jacob Hodge.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
Your Honor, Mr. Hodge will be pleading no contest.
I mean, no contest to that charge. Thank you, counsel. Sir, do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yeah.
Okay. Basis for a no contest plea?
Potential civil liability, Your Honor.
Sir, to the charge of retail fraud second degree, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had one caused to one to be signed on your behalf? Do you have any question
Your Honor.
regarding those rights?
No.
All right. You understand that you're waiving or giving up those rights, particularly the rights contained in paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Were you on probation at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Is that a yes, sir? I'm sorry, you broke up there.
Yes. Yes, Your Honor.
All right. Court has reviewed. I have it here. Pittsfield Township Department of Public Safety report for their case number 26665. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
We're satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
26 at 12 noon.
26.
Yes.
August 26, 2026, 12 noon. Before me. Bond continued. Thank you.
Thank you, Your Honor.
Court calls the case of people versus J. Peter Avestia. Right, Avestia.
Bring those to the people.
Bench warrant yesterday.
And Assistant Public Defender Natalie Pate on behalf of, and I believe with, hopefully on Zoom, Mr. Peter Abijah. Sir, if you're there, can you please unmute and state your name for the court?
You have to you have to unmute. I couldn't hear a word you said.
Good morning, sir. My name is Peter Ivezai. How you doing today?
I'm doing great. Thank you, sir.
Thank you, Your Honor. Thank you, Your Honor. I do have a green sheet. So I know my client was set in front of Your Honor yesterday for during the misdemeanor docket. He didn't appear on Zoom. Obviously, he submitted the bench warrant recall since then, and that was recalled. So I did want to thank Your Honor. And I did have a subsequent conversation with him. He found someone to help him out with Zoom today.
Okay.
So he's here. We're grateful for that. So, and he's been working with our mitigation team to get some mitigation together. He has met with them previously, but has another appointment scheduled tomorrow, I believe, in person with them downtown. So we do not have that report yet. So we are asking for an adjournment so that that can be finalized.
All right. Without objection, August 13th, 2026, 9 a.m.
Thank you, Your Honor. Thank you, sir.
God bless
Thank
you.
you. Thank you. And to you also, sir.
Thank you.
Court does call the case. People versus Demetrius Jefferson.
I just felt this for the season.
Mayor Lucas, on behalf of Mr. Jefferson, if you could please state your name.
Demetrius Jefferson.
You're requesting an adjournment.
Yep, for continued negotiations.
August 13th, 2026, 9 a.m.
Thank
Court
you.
calls the case. You're welcome, sir. Court calls the case. People versus Walter Junius.
Assistant Public Defender representing Ms. who's approaching the podium.
Your name?
Walter Junius.
Your Honor, we are requesting an adjournment. We have requested some discovery.
During the matters to August 13th, 2026, 9 a.m. Both cases. Bond continued.
Thank you, Your Honor.
Wait. What did I do?
Sorry,
Your name, sir?
and Keener.
All right.
Your Honor, I'm currently retrieving some mitigation information from Mr. Keener's therapist, like to present to the prosecutor. I would also like to address his bond conditions.
He's out.
Yes, Your Honor.
Okay.
So Mr. Keener's.
You want to go or let me go?
My apologies.
No, I'm sorry. I'll adjourn this to August 13th, 2026, 9 a.m. Go ahead as to your bond argument, Mr.
Thank you. And Mr. Keener is currently on home confinement. He's very eager to be able to return to work. We would ask the court to consider changing it to a hot zone tether. In the alternative, he is indicated he would like to request a change of home confinement address to his father's home. And I do have that address, which I can provide to the court off the record.
Response.
Your Honor, I would have no objection. I would ask the home confinement stay, but I would ask that he would be allowed to have out hours for documented work if it's provided community corrections, but then he used to return home, given the previous bond violations.
Yes. Okay. I will do that, Mr. Lebo, if you'll prepare an order to that effect. As to the change in address, I'm not going to have an issue with change of address as to where he is.
Thank you. I'll prepare an order and put both matters on that.
Okay. All right. Thank you.
Thank you.
Check up on continue.
Bond continued. Thank you. So great. Just checking. Court calls the case people versus David Kahn.
Assistant Public Defender Emzo Hutchins on behalf of Mr. Khan.
You know where he is?
I do not, Your Honor.
Khan. No response. Bench warrant will issue for defendant's failure to appear. Bond 10,000. Cash surety.
Thank you, Your Honor.
Court calls the case people versus Antonio Lewis Gardner.
Assistant Public Defender Davi Leba on behalf of Mr. Lewis Gardner, who is on Zoom.
Really?
Expected to be on Zoom.
I'm here.
What's your name?
T. Antonio Lewis Gardner.
All right. I'll just call him Lucky Lebo. All right.
Thank you, Your Honor. I'm requesting an adjournment for Mr. Cantonius, Mr. Lewis Gardner to pick up and review some discovery. I did just want to briefly address a bond condition.
I'll adjourn it to August 13, 2026, 9 a.m. Yes, that's the bond.
With regard to bond, Mr. Lewis Gardner is currently required to engage in regular testing at community corrections. Since he's asked me to request that the condition be removed, he has some concerns that he's made about having the money for testing as well as returning to Ypsilanti for testing. Additionally, the case itself does not involve any allegations relating to substance use.
Any response from the people?
I'm asking for it to be removed that there is no substance use involvement in this case.
I would leave it in the closed session.
I'll remove the testing requirement.
Thank you, Your Honor.
But otherwise, this bond will continue. You understand that, sir? Sir, you understand what I just did? Frozen.
Yes.
Okay. Won't worry about it. I'll let Lebo explain it.
Yes, Your Honor, and I will. Thank you.
Court calls case People versus Trevon Bridges.
Assistant Public Defender. Assistant Public Defender Chinaza Carey, I can rule, Your Honor, on behalf of Mr. Trevon Bridges. Mr. Bridges,
Hello?
state your name for the record.
Mr. Trayvon Bridges.
Okay. Gotta go sometime after it. I mean, is his travel all, he's all set? If I do August 13th, he'll be here?
Yes, Your Honor.
All right.
Is that right, Mr. Bridges? You'll be back on the 13th? I mean, you'll be here on the 13th, right?
Yes, I'll be here.
Okay.
Okay, August 3rd, 2026, 9 a.m. Bond continue.
Thank you so much, Your
All
Honor.
right, have a good day.
You do the same. Enjoy the weather.
I will try to. You too.
Court calls the case People versus Rodney Clark.
Assistant Public Defender Chinazi Carey, I can really on behalf of Mr. Rodney Clark, who should be on Zoom, Judge. Mr. Clark, could you state your name for the record, please?
I'm Rodney Clark.
Your Honor, we are asking, we're asking that this matter be set for preliminary examination, Your Honor.
Discovery is complete.
To our knowledge, Judge, yes.
So other witnesses available the 28th. Preliminary examination, July 28th, 2026. 12 noon before me.
Thank you, Judge.
Well,
Thank you, Your Honor.
court calls the case People versus Malik Cook.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Malik Cook. Mr. Cook is to my right. Mr. Cook, state your name for the record, please.
Thank you.
Judge, I'm giving the court a green sheet in this matter. We are still in negotiation.
He is one. Are you sneaking one in? Hold on a second. See, I can't.
I'm giving. Giving Mr. Allen the evil eye.
All kinds of things. This people in Mississippi.
That's
sneaking.
all over the place.
Was this a case I already called?
That.
Bridges. I already did that.
You did. Yes.
We just didn't have the greens.
That's right, Judge.
Your Honor, Andrew Cito, PH 7447 on behalf of defendant Sarah McFarland.
No, we'll watch you get dressed.
Thank you.
No, it's okay. We'll wait.
I'm ready.
You good?
Yes.
Is that a double Windsor or what? Never mind. All right. Client here.
Yes.
Okay, state your name, please, ma'am.
Sarah Lynn McCormick.
All right, thank you. All right, what are we doing?
Your Honor, the prosecutor and I have reached an agreement. We submitted the paperwork and I would like to move for immediate sentencing if there's no objection. I don't think there is. It's possible.
Do I have paperwork? I have no paperwork.
Okay. We did sign the plea agreement and we sent it back to the prosecutor. I'm not sure if I was supposed to file that or.
I apologize. My understanding was that it was filed with the court by the defense attorney.
Oh. So they thought you.
I could have. I'll just double check right here. Just give you 1 second. Good morning. I sent it to Miranda Dover. Yeah. Are you Miranda Dover? The prosecutor's Dover, right?
Yes.
Yes. Okay. I only sent it to the prosecutor, so I did not send it to the court.
Okay, so I didn't get it, which I knew about 5 minutes. All right, so I have to adjourn it out because I gotta have paperwork.
I will file it.
Well, thank you.
We'll take the next hearing available.
As you are, the defendant is
In custody. Yes, they're gonna have to writ, and I don't have the 2 weeks out necessary for a writ, so I will adjourn it to August 6th, 2020, 9 a.m. or as your invite indicates, bond will continue. All right. Thank you. Thank you, Ms. McCormick.
Thank you.
Court calls case, People versus Patrick Lay.
Michael Vincent on behalf of Patrick Lay.
Your name, sir?
Patrick Lay.
Mr. Vincent? Happy birthday.
Been pretty happy so far.
Huh?
Been pretty happy.
Has it? Fantastic. Guess my staff let me know, but we got you nothing.
84.
84? Yeah. God bless you.
I did my workout this morning.
It worked. So did I. I got coffee. All right. All right. What are we doing on this?
We have a restitution that we agreed to $1,685 some cents. We were here last time and nobody knew who was going to take the check. We have the money lined up through your folks up in Tawas, right? The folks are up in Tawas. They're ready to send a check. We don't know to who.
Okay. And the court can't be involved in that. So do you guys need an adjournment to sort all that out? Or?
I'm standing in for APA to on this matter in Sacramento. And so we would
An adjournment. All right. I'll put it over. This matter, probable cause conference to August 6th.
Can my client be excused for showing up? And if they just give me the address or somebody to send it to, as much as I love coming in here,
I mean,
it's my favorite thing.
Gonna try to get it the own birthday present. Is there going to be an idea that this case might go away? Is that, maybe I don't need an answer.
I'll come.
That isn't, and
I'll be here.
And I will excuse your client from.
All right. Thank you.
Thank you.
Because I like seeing him. It's Vincent. That bothers me.
Your second favorite thing, right?
All right.
Thank you.
Thank you. Okay. Bond will continue. Court calls case People versus Patrick White.
Afternoon, Your Honor. Dan Garrett on behalf of Patrick White.
Your name, sir?
Patrick White.
Thank you.
Your Honor, I'm asking for an exam date. I believe discovery is complete.
People have their witnesses available the 28th.
Your Honor.
All right, set preliminary examination, July 28th, 2026 at
9 a.m. for Judge Fresh.
9 a.m. before Judge Freshow.
Thanks, Your Honor.
All right, thank you. Bond continue.
Thank you, Your Honor.
Thank you.
Court calls the case of the people versus Zachary. Is that Halhowski?
Correct.
Deeply, Your Honor.
And Your Honor, Joe Simon on behalf of Mr. Halhowski. Mr. Halhowski, state your name, please.
Zachary David Halhowski.
Thank you.
Your Honor, I've been corresponding with Ms. Dover right up to this moment, actually, and we're requesting an adjournment of the PCC to determine the ability of the case to proceed.
All right. Well, August 6th work for you, sir.
Yes, Your Honor.
August 6th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Why did Simon's thank you not sound so received?
Because I'm still celebrating Mr. Vincent's birthday in my heart.
Okay. Oh, that explains it. Court calls the case. People versus Dominic Brewer.
Albert, on behalf of Mr. Brewer, who is approaching the podium and will be standing to my right. Mr. Brewer, please state your name for the record.
Dominic Brewer. Thank you.
Your Honor, today is the date and time set for probable cause conference. We are still working on discovery. We're asking for an adjournment.
August 6th, 2026. No.
Thank you, Judge.
All right, thank you. Bond continued. Court calls the case. People versus Kwame Edwards.
And on behalf of the people, Your Honor.
Edward Lucas on behalf of Kwame Edwards, who is approaching, Your Honor. Yeah, I think we are close to a resolution. Prior to setting it for an exam, I'd ask for an adjournment. We can push it.
All right, would you be able to get it? Are you close enough that if I set it for the 28th in the morning, you'll have it? Or that's a Tuesday?
Or I was looking to avoid that Tuesday date, the 28th. If we could do after that.
Why is he avoiding date?
We have an evidentiary hearing at 9 and it may go most of the day.
August 6th.
Thank you, Your Honor.
August 6th. Thank you, sir.
All right.
Thank you. Court calls the case versus Gerald, is it Marhoffen?
Bring the door.
Good afternoon, Your Honor. Deanna Kelly appearing on behalf of Mr. Marhofer, who's approaching. Your Honor, would just read.
Gerald Marhoffen. Sorry. All right, go ahead.
Your Honor, we're requesting just a short adjournment. I substituted in for the public defender. We're requesting discovery. I know they've already taken steps, the public defender's office, to forward it, but I don't have it yet. So like a short adjournment.
I can do the 28th or August 6th.
It will, okay. August, which date?
6th.
That works great, August 6th.
The 6th.
Thank
All right.
you.
August 6th, 2026, 9 a.m. or as your invite indicates.
Wonderful. Thank you very much. Nice to see you.
Thank you. Court calls the case of the people versus Jeremiah Meese.
Ashley, help us with the people.
I'm here.
Good afternoon, Your Honor. Robert Ellman with and on behalf of Mr. Meese. Mr. Meese, please state your name.
Jeremiah Meese.
I need you have a camera, Mr. Meese?
Yes, sir.
All right, thank you. All right, what are we doing?
Your Honor, today we'll be waiving exam. There's been an offer from the people for Mr. Meese to plead under HIDA, and he'd like to take advantage of that at circuit court.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing? You'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right
To raise right, Your Honor, I will note for the record, defendant is of the age where the people do not have to consent to hide him.
Got it. Preliminary examination having been waived, defendants bound over to circuit court on the single count. Mr. Elm.
Thank you, Your Honor. We would waive any formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
September 14th at 1:30 with Judge Kamudi.
September 14th, 2026, 1:30, Judge Hamoud.
May I have just one moment, please?
Yes, you may.
Thank you, Your Honor. There was a co-defendant on this matter. I was just verifying that person was also in front of Judge Kamudi because I think the court knows how that could happen.
Yes.
What was the date?
September 14th.
Thank you, Your Honor.
Bond will continue. All right. Thank you.
Thank you, Your Honor. Very good to see you.
Good to see you, sir.
Can I approach, Your Honor?
Yes. Court does call the case People versus Rayshawn Dawson. 2 cases.
Good afternoon, Your Honor. James Fifelski appearing on behalf of Mr. Dawson on the case ending in 5307.
Good afternoon, Your Honor. I'm Zoe Hutchins, Assistant Public Defender, also appearing on behalf of Rayshawn Dawson, in case ending in 0645.
All right.
As you can see, Mr. Dawson is not here. I've checked the hallway at least 3 times, and I know co-counsel has been checking as well. I have not heard from him personally. I would just ask the court to issue a show cause.
Yeah, that's happened. Bench warrant will issue for defendant's failure to appear. Bonds will be set in the amount of $10,000 cash surety on both cases.
Your Honor, the defendant also has a community corrections violation for not reporting for testing.
I didn't see that.
It just came through this morning.
Got it. Okay, so it's bound to my, I got it.
And is that on
both $25,000 cash surety?
Is that for each file? Because I didn't see a bond violation on the 5307.
It's gonna matter. The bond, this particular bond violation was just on 0645.
Okay. Thank you.
Thank you, Your Honor.
Court calls the cases of the People versus Freddie Anderson.
She told us for the people.
Deborah Geraldine Bledsoe Ford on behalf of Freddie Anderson.
And oh no, you're fine, sir. And Assistant Public Defender Natalie Pate with on behalf of Mr. Anderson in the case ending in 1055. Mr. Anderson, say your name for the court.
Freddie Anderson.
All right. What are we doing?
I'd like to join with the defender and her plan. My client instructed me what her plan was. It's an adjournment, I believe, to get him treatment.
So, Your Honor, yes, I was going to be requesting an adjournment possibly of 2 weeks. Mr. Anderson had provided me the information today that I need in order to submit a referral for the recovery court here in Washtenaw County so that hopefully he can be screened for that.
He was on the verge of being evicted, and all he wanted was one more chance. This courtroom hearing wasn't about a violent crime or a dramatic criminal trial. It was about something millions of people fear: losing their home. A tenant appeared before the judge after falling behind on rent. The landlord was asking the court for possession of the property, and the amount owed had climbed to more than $1,100. When the judge asked how he planned to pay the debt, the tenant didn't make excuses. He admitted he had fallen behind financially and told the court he believed he could pay everything by September. He explained that he had loaned money to someone, struggled to keep up with bills, and desperately wanted to avoid eviction. You could hear the stress in his voice. But the judge had to explain an important reality. The court couldn't simply pause the legal process for several months. Instead, the judge encouraged the tenant to contact the landlord directly or work with the landlord's attorney to negotiate a payment arrangement outside the courtroom. Then, rather than issuing an immediate eviction order, the judge gave him one more opportunity. The hearing was postponed for 1 week. The message was clear. Use this time